Ever heard the phrase possession is 9/10 of the law? Well, you might be closer to the truth than you think. My name is Jason Weeks and I'm a co-founder at vendorable.com, a platform for real estate services, and I thought I'd talk to you today a little bit about property title. One of the things that we often are asked by clients, firms and people who use the platform is, what information do you need in order to use the platform and sell a property? And the obvious answer is, well, do you own it? And it's not as simple as you would think, depending on the jurisdiction you're in, to prove, quote unquote, ownership of a property. You see, property title is the term used to indicate ownership, but ownership is not specifically the word that lawyers or people who operate land registries use. They think of property title as a bundle of rights. And the easiest explanation that I can give you up front as to why there is a bundle of rights is not all land has the mineral rights attached to the asset. So for example, you could own a property, but you might not necessarily own the oil and gas underneath the land that people might drill or mine or seek permission from you to drill or mine and compensate you for, but you may not own it. They may need access to your land to get at minerals that they have purchased separate. Similarly, there's a difference between a legal title and an equitable title. So there's a myriad of things to consider in property title in terms of how they could be separated, how it could be constructed, and how people think about it. But I started with the phrase possession is 9/10 of the law because in fact it is actually a good indicator as to who owns a property. Because if there's insufficient information about how a property has been held, how it's been passed through generations, how it was acquired, then possession is 9/10 of the law, because if you're on the land and possession is not disputed and you've held it for a certain period of time, then most jurisdictions will deem you to own the land. And that's quite commonly what you would see in the press as people squatting until they owned the property. And there's been recent cases even in Australia where people have not maintained properties. There was one recently that was a sort of a $1.5 to $2 million property in Sydney where someone came along, assumed ownership of it, renovated it, started renting it out, and a long enough period of time passed that the court said, well, look, if you really cared about owning the property, you would have actually taken control of it, possession of it, and started using it. There are a lot of factors in that case, but it did come down to not taking possession, ownership, and use of a particular property, and therefore losing title in the property. So although possession is 9/10 of the law, actually the reality is that the rights of property defeat all. And so the idea is that in order to sell an asset, or in order to have confidence in purchasing an asset, what you're looking for is known as good title. And good title is simply the intersection of the right of possession with actual possession combined with the right of property. So let's go through that again. It is the right of possession, actual possession, and then the right of property. Now look, that's not necessarily going to be easy to establish. It may often be contentious. It will change over time, and it does change with additional evidence. So two of the ways that are quite common with dealing with this in terms of a systems approach, as in terms of government and in terms of interactions with sale of property, are what we see in, say, the US versus Australia. So in the US, you often have title companies, and they will write reports and they will look at the chain of title and documentation at multiple levels of government, local government, state government, potentially even federal title, depending on where you are and what type of asset it is. And then you have what we have in Australia, which is Torrens title, which inherited its name from Robert Torrens, the Premier of South Australia, and 1858 around there. Although there's some contention between people as to whether other jurisdictions came up with it first. But the idea that is the government has a land registry, and the government will maintain all of the information relating to title, and they will have the conclusive evidence as to what indefeasibility of title is. So ultimately that means is there can't be any qualms, there can't be any disagreements, and what the state goes in terms of who owns an asset. I can hear all of the sort of libertarian bells ringing for those people who don't like the idea of government controlling land ownership. But what it does decrease the dependence on is things like title insurance. So although title insurance does exist in Australia, it would be wrong to say that it doesn't. It doesn't exist to the same level as it does in America, because ultimately the government holds the information relating to property title, and all requests to amend title or lodge interest in title are therefore centralised. They're not potentially separated amongst a number of different jurisdictions, a number of different companies, or in fact not even lodged anywhere, even though they may exist as some sort of interest or right to title. So that centralisation was one of the attractive components of that type of title system, Torrens title, and why it spread throughout the Commonwealth quite aggressively, because it created greater simplicity around property title and therefore transfer of title and registration of interest in title. And the idea was that it was designed to improve trade and commerce in and around property and associated rights. It would be wrong to say that it doesn't exist in the US to a certain degree. There are some jurisdictions, about 4 or 5 jurisdictions, you can look them up, that have implemented some components of Torrens title, but it would be inaccurate to say that they have the centralisation of title to the degree that, say, Australia in its states and territories does. So, as I said, 2 types of title manifest. So the idea that there is a bundle of documents, information held by a land registration service, or title department of property, and then the idea that private organisations will write title reports, do their best to research historical ownership of a property, and then ultimately provide title insurance over that in case your title report is inaccurate or there's information missing that comes to light later. So again, why do we care? Well, fundamentally, there are 3 main reasons why we care. The first is, if you want to sell an asset, you're going to have to provide this information to your attorney or your solicitor, and they're going to have to provide that information to any prospective purchasers, because funnily enough, people don't like buying property off people who don't own that property or don't have the right to sell that property. So establishment of title is important for the sale of an asset. It's also important for the registration of interest in an asset. So the second point is often debt, and we've spoken about debt before in the context of rent vesting. You can look at that video and how it affects valuations. But interest in title is something that lenders and financiers are always keen to have, both in terms of the initial registration, that is proving you own the asset to borrow against, and later on, if you approached another lender either to refinance or for an additional loan, who is already on title, so are there already other interests? And in America, for example, you might have property taxes that have liens against title, and there may be people who have purchased that and have other interests. So there's a few reasons in the lending community as to why you would want to have a good understanding of title. And then finally, depending on which jurisdiction you're in, there is obviously a lot of focus on native title. And so the idea of pre-existing possession and rights and dispossession from land of people who moved into a jurisdiction, and there was ownership of the land that is able to be established that predates regimes such as title in America and even title in Australia. And those things are often dealt with by the courts because they will require a significant amount of information relating to proof of ownership, proof of use, associated individuals, groups, and then the subsequent management and ongoing use of that land. And then there's also the idea of access to land now versus past, and then compensation, so native title. And then finally, what we're seeing more and more is understanding of property title for mineral rights. And the reason this is becoming important is the ability with new technology to maintain ownership of the land at the same time as granting access in a subterranean capacity to mineral rights, and then how those rights are owned either by the government or via individuals, or how they're leased to companies, and those sorts of things. They can be preserved during ownership of the land. They can even be separated from title depending on your jurisdiction, and then and they can be maintained then by other owners who sell you the land on top. So mineral rights and that associated possession is a keen area of interest. But ultimately, if we come back to my first point about possession being 9/10 of the law, I hope you can appreciate property title is something that you may not be accessing on a daily basis, but if you are interested, you should definitely have a look at your property title documents. So go back to your original contract for sale and purchase of the land that you bought, ask your attorney or solicitor if you can't find a copy of it. They will definitely have one on file. And also talk to your family about where their title documents are, because it's a big part of estate planning is proof of ownership of a property in the event, unfortunately, that someone passes away. So having access to that information if you're in a jurisdiction where you're supposed to hold it, or alternatively understanding in what entity it's held, such that you can contact the Land Registry Service relevant at the time. But property title is a really important part of what we do. It's an important part of if you want to transact, sell, lease or value a property. So I definitely encourage you to at least look at it a little bit, and some of the history of it's pretty interesting. Thanks very much for watching.